because of that document, or you just need, you only need more time to read the document?
Well, let me say that is the wrong report that you people put out there. I didn't ask for an adjournment. An adjournment was compelled. The witness to be examined, that is the substitute for the DG, was available. The prosecution legal team was available in court. The defense legal team was available in court. The court and the judge and all the paraphernalia were there. But what happened at that stage was that an important document with which the examination of the witness was to be based had been applied for. A certified true copy of it had been applied for by us. And it was applied for weeks earlier. When you file the process in court, it is for you, anybody, whether you are a party to the case or not, once it is filed, it becomes a document that is accessible to anybody. That is the reason why, for instance, I can go through, if I'm interested in any particular case, or the outcome, the records of any particular case in America or in UK, even though I'm not a citizen of America or whatever. Once I have the details, I can apply and obtain it. But the Federal High Court has a peculiar procedure. I don't know what led to it, because you are supposed to make that application to the registry of the courts. Because it is at the registry that those documents are filed. But the Federal High Court has a peculiar procedure. Once it is an ongoing case, they tell you that the judge has to approve it, has to approve that application before they can then proceed to issue the certified copy of it. So that was what happened. So even though the document was applied for weeks before that date, and I will tell you the reason, the background to it subsequently. Even though it was applied for weeks before, and we were sending someone to follow up, as it is in our country, things don't go the way they are supposed to go if you don't follow up. And you can't even blame the registry. For instance, in that court now, the court sits from morning till almost night, and the registrars are there. So where do they even have the time to look at those administrative issues? So unfortunately, we kept on going, and our emissary or our clerk was persistently told that the judge hadn't signed the documents. In desperation that morning, I sent someone again to be sure, and the person was told again that it hadn't been signed. So when I got into the courtroom, I then asked one of my lawyers, the person going was a clerk, so take a copy of this thing to show to you. Why is the thing not ready? We can't go on because these documents is required for today's proceedings. We won't be able to go on without that document. So a senior member of the registry took the letter and started a painstaking search through the files, only to discover that, contrary to the information that we had been fed all along, the judge had approved a thing, had approved it. So the next thing was, okay, we still have some time. Can we quickly rush to get the certification done so that the proceedings of that day will not be frustrated? That's also proved impossible, because they now said they have to take the file physically to the place where the photocopy of some responsible officer would take the photocopy and then do the certification. So it was impossible. So that was what happened. In that circumstance, it was a situation forced on, there was no option. We can't go on without the document. We didn't go on. So, and there was no attempt to blame anybody. So that was what I explained to the court, that look, this is the situation we are in, and we cannot, there's no way we can, it's not possible, because that document is like the foundation of what I was going to ask, the questions that were to follow. And previously, to avoid that kind of situation, the document itself was something served on the defense by the prosecution. The document emanated from, it was a filing, the document filed by the defense. So at the previous adjournment, knowing that we needed that document to ask the witness coming questions, we, had tried to put a witness in the box to say, okay, this is the document, served or not, just to put it in, so that by the time this witness comes, we won't be going through all that process. The prosecution opposed it, and the court agreed that it was that we couldn't use the one served on us, and we have to obtain a CTC of the one in the court's record. That was at the previous adjournment. And that same day was when we submitted. We didn't wait till the following day. We didn't wait till days after. Same day, as we were leaving the court, Sowore prepared this application, we submitted it, filed. And from that day, we kept on following up. So that was what happened. And I thought that my colleague, representing the prosecution, situations like that happen in court. You plan something, the schedule for the day, and so on and so forth. Something develops that will make it impossible to go on. It's not anybody's fault. Sometimes you go to court, the court is ready, both sides are ready, witnesses are court. I still use the old NEPA strikes. Generator is not functioning. The whole place is dark. Who do you blame for that? You can't blame anybody. You can't say that if I waited till that day to begin to make the application, that would be a different thing entirely. But that was not what happened. So I was, a bit, how will I put it? I don't want to use the wrong word. Rather than this is something that everybody could see has happened. It's not my fault. It's not anybody's fault. It's not your fault. It's not my fault. And I won't even say it is like I said. I won't even say it's direct. Of course, the court has to stop at someone's table. The truth of the matter was that the judge has signed it, so it's not the judge's fault. The judge will not go into detail. You brought something to him, he has signed. Unless we knew he had signed, we couldn't have been arguing with the people who told us that he hadn't signed it. We don't know. We don't work at the registry. If you say it was not signed, we have to, and kept on going there. And on that day, I said, look, even the person I sent that very morning is in court here, get up. The registrar that he discussed with and all that is here. So it's not as if one was making up any story. So when you now get up and then begin to use what I would call, and it's persistent. Even the very first day I came into the matter, the very first day I went for that matter, just to let the court know that I've now been engaged by Sowore, give us a date for us to open the defense. That was the date the court actually made this. Sowore had been representing himself in the, I think, 2 or so previous adjournments. He had filed an application for the judge to recuse himself. So it was on that day that the judge delivered his ruling. And immediately the court delivered his ruling. I thought, I'm now loyal to this gentleman. We are prepared to give us a date for defense. And my colleague was his reaction. If these things happen, there's nothing special about when a new counsel comes into the matter, you at least allow a little bit of, give me a date so that I can begin to call our own witnesses. And he said, was being, what I would call, very, offensive language, denying. I said, how can I be delaying matter? I'm just coming into the matter. This is my first day in this matter. So how can you say I'm delaying matter? Yeah. So that was what, and persistently, every time things like that happen. Yeah. So that was what led to that incident. So it had history. It had history. For instance, let me give you one that was, and I'm saying this with all sense of responsibility. The day we opened our defense, Sowore's defense, the first witness is a gentleman called Adjourned. That was the person we called. He's a lawyer. He was to have a case that morning before another court at the Federal Capital Territory. I had to appeal to him, just find a way to take an adjournment in that order so that it could be here. Because if I hadn't presented it that day, this talk of, we are trying to dodge, we are trying to put that reason. So when we got to court that day, and Adeyanju came in, it's a case where they've been using video evidence and all that. So usually there's supposed to be arrangements for that to do. So when we got to court, and even though we had applied for it to let them know that we will be needing those facilities in court that day, we didn't need to apply. And it's a case where they had already used it. So if somebody had already tendered a video record, you should anticipate that if another witness comes, you may need to play that video evidence to that person in order to be able to. So we didn't need to apply, but we did apply just to give them notice that we need. Unfortunately, the arrangement couldn't be made by the court that day. So when they got into the box and wanted to, I said, how do we save the day? Here was the day that we were brought in, at great sacrifice to his own time to testify. So how do we ensure that the day is not completely wasted? So I said, okay, I could reorganize my questioning in a way that I will stop at the point, I will end it with where our own video evidence needed to be played. The court would have admitted it, and then we can then, so that the day will not be wasted, and then an adjournment can then be granted so that by the time they make provision for the video or whatever, it will just conclude its evidence, and the defense will be able to cross-examine. That was the agreement. And then we agreed. I think it was on a Tuesday. I can't remember the exact date of the week. Whether it was on a Tuesday I think it was on a Thursday. It was on a Thursday of the week. So the understanding was that, the initial understanding was that he will come back on Friday, the following day. The video, whatever, will be played to court, and then he will be cross-examined. Then I told the court that I was going to, that was the understanding. By the time we finished with him on that day, he then notified the court that he was actually supposed to travel that afternoon to Sokoto to go and represent another client of his, and that he will not be coming back until the following week, so that the Friday date will not be possible. I had earlier informed the court that, look, my daughter was graduating the following week outside the country, which was the reason why I wouldn't be available for any, so that just do it. My colleague, a junior colleague in Abuja, there's nothing no harm will be done. Him coming to conclude the evidence that we already led through DG, and then for the prosecutor to cross-examine that witness. And we agreed that, okay, within this space of 1 week that I will not be around. Please help us. If you are going to grant any adjournments, don't let it be within that period so that I can be available. That was our understanding. So by the time we finished that day, and the general said that he was not going to be available on the Friday. So the court was there. So what will now happen? And I said, there's no problem. I'm the one that will not be available in the coming week. We can adjourn it to a day during that coming week for that purpose. I didn't need to be there. But when you are granting an adjournment, just bear in mind that I won't be around. I'm not around. I can show you my tickets, my everything, the fact that I went for. So it wasn't anything hidden from the court. I was, of course, it went as I said, only for me to hear that, I think it took place either Tuesday of the following week, the completion of the prosecution, defense witness number 1 took place the following week. He was cross-examined and he was discharged. So he now came give us an adjournment for the second prosecution defense witness. Only for me to get a report in London where I was that the case was adjourned till Thursday. Do you understand what I'm saying? Yeah. I said, why? This is not what we agreed. Why should I have adjourned till Thursday? I won't be available. I'm not around. And it's not something unknown to both the prosecutor and the court. So it's not as if one was taking them by surprise. And this was our agreement. I said, well, there's nothing I can do. I have to. It was, I think the graduation I went for was actually taking place on that same Thursday. So I was abroad when some lawyer colleagues started calling me that proceedings took place. I absented myself from court because we are dodging to delay, we are dodging, we don't want So I was surprised. So I picked up my phone and then called my learned brother, the prosecutor. This is what I'm hearing. Of course, we were not there on that day, and the report was that they went to court. Oh, of course, Sowore was there as the defendant. They said, where's your lawyer? The Sowore now reminded the court this was what transpired at so and so and so. The report, I wasn't there, but the report I got was that my learned brother, the prosecutor, went on and on about we dodging, the case should be closed, the defense should be closed, so on and so forth. Of course, the judge didn't oblige, other than saying that be serious with So they now adjourned to the following week, which was what should have been done in the first instance. So when I started getting this report, I then called from there, Mr. Kendi. I said, what happened? This is not according to what we agreed now. The court is busy. The court has so many cases, especially when it is not recorded. These are a lot of discussions take place in court without the court recording. The court has so many cases, may not remember, but you should. When the court wanted to grant an adjournment, I would expect that you, as mine, should have reminded the court, my brother is not going to be, reminded the court that this was what transpired and so on and so forth. But I'm surprised that you now went to say the case should be closed, we are running. He said, no, that was not what happened. That I should not listen to internet, whatever, was I there? So I said, but all the papers are reporting the same thing. I said, okay, no problem. So by the time I got back and we went on the day they now adjourned, so I told you, I raised it in court, that this was what happened. And the court was saying, it was because my lawyer was asking for a date after vacation. That was what prompted him to fit it for the date. And I said, well, I'm not blaming the court. To my mind, the court may not even have remembered. But I expected my colleague to have reminded the court. Nobody is trying to play games with the court, contrary to the impression that is persistently created, that somebody is running away from trial, so on and so forth. That even if the court will take, based on that reasoning, you don't want to give a date after vacation. We are not yet in vacation. After all, we are here today. It is not the week we are talking about. I see all this as an attempt to just conduct trial in the media, give a wrong impression about what is going on in court. And that I feel that that should not be the case. You know? So when we go back this time around and the same thing I've explained to you, these are things you can go and verify. I can give you copies of the application. If you are available, I will give it to you now. They'll print it out with the date the thing was received. You know? So mine is to prepare my case. If the court is not in a position to take me, how am I to be blamed for that? I hope you understand what I'm saying. If the circumstances in the court is such that we cannot go on, how is it my own problem? So that was what happened. And when he, started again on this, he was using very rough words. It's not here, and I don't want to. And this is not okay. You know. And in any case, what is special about Sowore's case anyway? Which is what I don't know. And when he said that we are trying to dodge how? Yeah, I believe, if not all of you, some of you will be judicial correspondents. When court declares vacation, only vacation judges are supposed to be sitting. Any judge that sits is breaching the law. Unless with the prior consent of the party, and even with the consent, you must still take the permission of your head, the head of the court, the chief judge, to say, I'll be sitting on so date. So if we didn't want the case to go on, we don't need to go into all those drama. We just tell the court that we cannot sit. It's vacation. The judge is not a vacation judge. And there's nothing, do you understand what I'm saying? So we didn't need to go into any drama. To go into drama of bringing people to court and then say we don't have a document and all that. If that's the reason, if that's what we wanted to achieve, is just to prevent the case from going on, we don't need that drama at all. All we needed to say is that, sir, this court is on vacation. You are not supposed to sit. In fact, I may not even have gone there at all that day, and he can't do anything. Do you understand? Even with the adjournment to that day, if I didn't turn up, nothing will happen. Because the court is on vacation, it can't do anything. But we all agree that we were coming on that day for a purpose. And you can see I'm not based in Abuja. I'm based in Lagos, yes. Do you expect me to leave my office here to go and personally camp myself in the courtroom because I want to collect a document? I only use the people associates in Abuja to do so. And every day they were telling me, this is the situation, this is it. And these facts can be easily verified. You know? So this idea that somebody is dodging defense, I don't want to comment on the merit of the case. That's for the court to determine. But those who know me know that I don't engage in frivolities. You can find out. Those who practice with me know I don't engage in frivolities. If there's no merit, if I don't have anything to urge by way of a case for my clients, you won't see me in court. I won't go there. And if I go there, it will be for the purpose of, getting the best in terms of whatever I can get to, if you want to plead guilty, you play bargaining when it's a criminal matter, So I don't think that we do a lot of unnecessary drama. We served the subpoena, it came to court to oppose the subpoena on the DGDSS. But in the course of argument, we had what I said. I'm not interested. I don't want to embarrass anybody. I only want evidence for my client. I don't care from whom I get that evidence. It doesn't have to be maybe people think that, they are bringing DG to make noise. No. I'm not interested in all that drama. Just bring somebody who can testify as to the content of a particular document. That's all I'm interested in. The DG himself does not have to come. Immediately, the Attorney General had me making that submission. He called me over, took the excuse of the court, called me over, we had discussion, said, if we provide another person, I said, okay. You understand what I'm saying? And that was how we came to, that's how lawyers are supposed to behave. We have to head the courts. Things that we don't need to be making noise and all that about, we should do it. That was what the Attorney General did that day, and I cooperated with him. But some lawyers will insist on, oh, it has to be this, it has to be. You understand what I'm saying? If you weren't there that day, the court would have had to make a ruling, make this, make you. It's not necessary. Lawyers are supposed to be officers, helping the courts towards the goal of justice, not putting roadblocks and all that. And that's it. If you look at the one I've given you an example of, I'm not saying it's I can't conduct my opponent's case for him, and he cannot conduct mine for me. If you file a document, you serve me, and I brought the document and say, this is the document that you served me, I want to tender it. Should you oppose it? It's your document. The worst you can do is take your own copy, compare it with the one I want to tender, see whether you get what I'm saying. And then say, you have tampered with this, so this is not what I served you, this is what I served you. Do you get what I'm saying? But you now say, no, you cannot, it has to be certified, it has to be this, it has to be that. Well, if that had not taken place, it would have gone on the last time. Because we wouldn't have to be pursuing this particular document certification and all that. Do you get what I'm saying? That's how I understand cases. Please get me. Yeah. I'm not condemning anybody or whatever. What I'm saying. And that's the reason why I brought out the example of the Honorable Attorney General. How he came to court to oppose something, and we were able to strike a compromise, which was acceptable to the court. So all of us are supposed to, follow that lead, that example, not, turn the court into a circus. I'm not saying anybody is turning the court into a circus. Please don't get me, don't misquote me. We are to help the courts to do this, not to put obstacles and all that, and begin drama that is not necessary. If I say, and it is established, we apply, the document is with the court, it's not with me. We apply for the certification, we've been coming. It is only this morning that we eventually got to know that, contrary to what we were being told, the court assigned it. Before the court came out to sit, we made effort to say, can it be certified? They said it was not possible. So what do you want me to do in that circumstance? I should just go ahead and be doing what I'm not supposed to do by asking questions that are baseless. So it was a situation forced on everybody. And I would expect that that's, if I were prosecuting, because the duty of the prosecutor really is not only to the state, it's also to the defendant. The prosecutor has duty to the defendant to ensure that the defendant is given all the time and facility to launch and mount a good defense for himself. It's not a cat and mouse game. The court is supposed to act based on evidence. You lead yours, I lead mine. In fact, if the prosecutor knows, that's our rule. If the prosecutor has evidence, knows of any evidence that may exculpate the defendant, which the defendant himself does not know, it is the duty of the prosecutor to make it known to that defendant. That's what I understand the prosecution work to be. But to go on and on and on, and every time, it is a waste of time. He doesn't want to do defense. If that was the case, I wouldn't be there. Even that first day that I came into the matter, rather than concentrating on the case, don't forget, the first thing I had is that Sowore should go and be locked up. Which I felt was, he didn't come to court on a particular day in whatever circumstance. But he was there before that. I was there with him. He was present. Go and lock him up. And then that's a major distraction. We now have to, rather than concentrating on defending him, first of all, to concentrate on how to even get him out of on bail. So those are the things that have contributed to, if you can call it slow. And it's not slow. I can give you timelines. The amended charge They initially filed the case in September against Sowore, Facebook, and X. September 2025 was when they filed it. They didn't serve or whatever until sometime in December. They didn't serve anybody. In December 2025, they brought an amended charge. That was, it was in January, sometime in January, they removed Facebook and X, leaving Sowore. So it was in that January, I think, that Sowore took his plea. I hope you understand what I'm saying. Trial started thereafter. Prosecution closed his case in March, called one witness, and closed his case in March this year. The previous legal team filed a no case submission, which they are entitled to do. And the court delivered its ruling on that no case submission in May this year, and called on Sowore to open his defense in May, adjourned to sometime in June or whatever. That same period was when Sowore filed his application. The other lawyers left, and Sowore was defending himself. He said, filed the case that the judge should recuse himself. They were on that. It was the ruling on that was delivered June 22. I remember the date very well. June 22 this year. That was the first day I was in that court school. And we were then given a date, some date, we eventually given, I think, 7th of July to open the defense. We are in August now. So where's the delay that you're talking about? You understand what I'm saying? Even those of you that are judicial, you know how long it takes, even from arraignment to get any date. So what is so special about the rest case anyway? What is so earth-shaking or significant to the progress of Nigeria or in it that this talk, he doesn't want to defend it, and so on and so forth. So that's just the background to the whole thing. And of course, you had the court telling the lawyers, both of us, that we should behave rightly too. The court will not fold his arm and be watching the counsel. Yeah, go on insulting yourself. The court has to caution us. We're duly cautioned, and I believe that that ends it. We'll try as much as possible. So ignore distractions, such distractions, and just concentrate on the work we are there to do, which is to defend, put in the defense for the defendants. So the court didn't say we are aligned. The court said we should. What happened was that I protested the use of certain words by the prosecutor, which I consider to be persistent attempts to cast aspersion on the defense. Persistent. It wasn't happening the first time. Each time we went to court, that was what was always. In fact, and you can record me as saying so, on one occasion, the court had actually persuaded him to apologize to me for these same words. I think it was on that first occasion that the judge said, but this gentleman is just coming in for the first time. How can you say that it's wasting his time to, and then reluctantly, he said, it's not, he didn't mean it that way as well. But subsequently, the same thing, persistently. I've given you an example of where we both agreed. I won't be around for this, One reason or the other, the court, gave a date that was known to everybody. I would not be around for things that are disclosed to the court. Should you now be making application that, they are running away, close this case? Is that good for a prosecutor? I don't think that it was the right thing to do. And those with whom I practice also know that I don't hide my feelings. You can quote me, I called him from abroad to say, Mr. Akende, why? Even if the court forgot, you should have been able to. And if the court insisted on that, the day you now came and you didn't see me there, you should remind the court that the reason why I wasn't there was because of so. Not to go on to say, close the case. They are trying to waste the time of the court, and so on and so forth. and then you go to the press on that, coordinated that sort of, because I read, they have their own press, whatever, where when you read, you see that they are writing the same thing, so it's the same story. So I didn't feel that was a tidy thing to do. And when I got to court the next day, I raised it. That this happened. I raised it, and the judge then explained to me that it was because my lawyer was asking for a date after vacation. I said, I don't have any problem with the court. The court can make decisions based on its own, but what I'm saying is that I expect, we are both senior advocates of Nigeria. We are not friends, we call ourselves brothers. That's the difference. Generally, lawyers we say my learned friend. Do you understand? Senior advocate, my learned brother. Should brothers be behaving that way to each other? So that's the thing. Brother is a higher, it's not the friend. Friends should not behave that way to each other. I don't have talk of brother. When I say, my learned brother, that's the difference. I'm explaining it to you. When I say my learned friend and my learned brother, So I don't have any problem with. The worst that can happen is if the court makes a decision that the court is entitled to make decisions. Our own is to make our representation. If the court makes a decision that I'm not happy with, I have 2 levels more to go. Court of Appeal, Supreme Court. I can't be quarreling with it, But I made the point in court that day that I didn't think that was a brotherly thing to do. If your representative in court should, So I don't hide. I'm not saying it behind his back. What is the thing? And at that occasion to say, okay, as prosecutor, sometimes the personality I'm defending, Sowore, controversial, I may have offended so many people, may have published something, whatever that has offended. I had the occasion to say, my brother, if this man has, if there's personality issue between, just, in this case, let's just, because I don't understand. There are things I can tell you now, but behind what happened in court, outside what happened in court, administratively, but I don't want to be seen to, dragging I don't want to. That if I tell you, you'll be wondering, is there anything personal between this person and the defendant? So.
Yes, sir. Now, do you agree with Mr. Sowore that the government of the day they are prosecuting him, they are persecuting him and not prosecuting him? Do you agree with
the government?
With that? Yes, the government of the day.
Well, I don't have any. See, I'm a lawyer. I agree. I have looked at his case. I believe there's a defense I can urge viably for him. And don't forget that the government doesn't come to court. Government is represented by individuals. The way we approach our work, the way I will approach my work as a prosecutor, as a defense lawyer, may be different from the way, of course, there was a previous defense lawyer in the matter, a team of defense, the way they approach it is not necessarily the way I'm approaching it. So impression may give some impression. I won't go to the extent of saying anybody is being charged for an offense in something they believe somebody, they've done the legal work and they think that it's an offense under the law. So nobody is above the law. But I do believe that there's a defense that we can urge on its behalf through witnesses, and that's what we are trying to do. At the end of the day, the court will make its decision. I don't want to go into the controversy of is it being persecuted or is not being, anybody can, we are facing the case as laid in court. I know why you're asking that. It's because, as reported, I'm said to have said the prosecutor is a persecutor. Is that not the reason why you're asking that? I said prosecutor is, in the heat of, when you are in the courtroom, in the heat you can. So if it's not meant as an insult to anybody, it's, I've given you the background why I felt, why are you doing this kind of thing? So it's not government. I didn't say government is persecuting. You can say that even myself as a defense lawyer, I've gone beyond my role as defense lawyer. Maybe I'm personalizing things. That doesn't mean that, do you understand? You are commenting on my own personal conduct. So it's not about government. I didn't mean to say anybody is being, even if that is what they are doing, my duty. Okay, let me give you, I don't want to go into controversial things. The current one in town is the one that is online. It's about one case in Lagos. Somebody charged for murder in Lagos, and then it is alleged that somebody is pinning the murder charge, or maybe even though it's not. That's what the court is there for. I hope you understand what I'm saying. Whatever, if you are wrongly charged, you go to the court as much as possible, bring your own evidence. And don't get me wrong, there are a lot of people in prison, sentenced to death, even killed for things they do not. I'm not saying the court is perfect, or that once the court makes a pronouncement that you are guilty, therefore you are guilty. The court is manned by human beings. Errors happen. Don't forget that when we go to, I know that this is what I don't know how to describe it well. I'm not trying to ridicule this court system. But really what we do in court can be akin to stage play, like Nollywood. Why do I say that? The judge knows nothing. He wasn't there when the thing happened. The lawyer for one side, but the lawyer for both sides, they are only relying on what they were told by their respective clients and what they can find out by way, maybe they did some investigation and all that. So at the end of the day, is the party that is able to tell a story, a storytelling, drama, is the party that is able to tell a story very well, present it in a persuasive manner, that may eventually win. It is that story that the judge is listening to. He wasn't there. He will now have to say, since this person's story is more plausible than this other person's story. So that's what the court really. It's not for if justice happens, most times it is accidental. If it happens the way it should happen, most times it is accidental and not. The Yoruba say, so many. In recent times, we hear about people that have been killed in America, sentenced to death, or some have been in life imprisonment only for DNA evidence to show that, they were never responsible for the crime. Well, so I'm not saying that once the court makes a pronouncement, that's the truth. That's not what I'm saying. A judgment, like I always say, is the opinion, some opinion of the judge. It's just an opinion. But that opinion, the reason why it carries weight beyond any other person's opinion is because it has the weight of law. It becomes law once the judge makes that pronouncement. That's what it is. So don't say, somebody has been sentenced to whatever, and therefore that's the truth. It may not be. So what I'm telling you is that in this case, to the best of our knowledge, we'll present our counter evidence. Place it before the court. We will tell our counter story. They've told their own story. We will tell our own counter story and try to persuade the court that justice lies on our side. So that is what it is. We'll do our best, and that's what we are about.